Today I'm honored to welcome Assembly Member Catharine Baker. Catharine has just been re-elected to the District 16 seat. She represents parts of Contra, Costa, and Alameda County. Not only is she our local representative, but she has been one of us and practiced with Hope Fenton for many years, representing businesses and nonprofits in civil litigation matters. She has also been very active in our community, a volunteer with the Diablo Regional Arts Association. She's worked with our local Girls and Boy Scouts. She is active in our local schools. She has two school-age children that live here in Contra, Costa. And she's a graduate from UC Berkeley School of Law. Go Bears. Go Bears. Her topic today is it seems to me very timely. She'll be talking to us about lawyers in public service. So without further ado, Catharine Baker.
Thank you. Well, thank you. I can't imagine that you wanted to do anything else a week after the election we all just went through. And start your morning off with hearing from, I don't like to be called a politician, but so I'm very grateful to get to be here and been looking forward to this. As much as visiting with elected officials right now may not be your favorite thing to do, I am eager to sit around the table in a room full of lawyers who are not involved in politics. So, very happy to visit with you. Also know that there's a little bit of, I don't know if irony is the right word, but here I am at a CLE day, and I no longer have CLE requirements. I don't suggest you run for office in order to suspend your CLE requirements, but members of the legislature who are members of the bar as well do continue to pay their dues to the bar. They maintain active membership, which I do, but they are exempt from CLE requirements. That might be something I have to work on in the So this morning I wanted to visit with you about a topic that I always think is timely, and that is lawyers in public service. What are they good for? I want to give you encouragement to know the punchline is not absolutely nothing. There are a couple of lessons I've learned in the last 2 years about the value of having colleagues in the legislature who are from the legal profession, as well as ones who aren't. And there's some general observations to make about it. There are also a couple of case studies I'm going to go into some detail about today, one of which is the subject of some handouts, because I do want to make sure you actually get CLE credit from our good conversation this morning. The more general observations are that many folks say, why is it the lawyers are always running for office? There are just so many lawyers in the legislature. Well, interestingly, there are relatively few in the California state legislature, certainly Assembly. Where they seem to go is Congress. So there's a very high proportion of congressional members who are attorneys. In the legislature, there are 80 Assembly members, and I think there's less than 12 that are actually practicing attorneys in the entire legislature. And you can skip all the lawyer jokes about sharks at the bottom of the ocean and everything else. It happens even worse when you're a politician. But I have seen some value, not only from my own practice, to having legal practitioners in the legislature, but also I've seen some not great components to it. The general observations are this. There's certainly skills and expertise. This is the obvious part. Someone may have practiced in an area of law that they then are on a committee in the legislature that becomes their area of specialty, and they are just a great voice for potential legislation. I've seen some legislation this last term where there were some changes to estate planning, particularly proposed to determine if your house would still be considered part of your estate value, if that would be part of something that had to be categorized for probate or not. That legislation did not pass. But there have been times, and that was promoted by an attorney whose practice was estate. There's a senator who is a bankruptcy attorney who does a lot of legislation related to bankruptcy. And they can bring that practice and that skill. That's pretty obvious. And that really applies to every member of the legislature, whatever their walk of life was before. Hopefully they are bringing the best of that experience and skills to what they're doing, and it allows them to bring some insight to the conversation. There's a lot of negotiating. There should be in politics, particularly in a legislative body where you're working out a deal. And there can be really terrific colleagues with practice in negotiations, reaching a compromise, coming to the table and trying to work out a deal. That's an obvious skill that we can all benefit from for our clients if we are better at negotiating and have practice in actually doing it for several years, hopefully. Whether it's smaller matters, if it's matters that are particularly complex, or if it's multi-million-dollar matters, that's good practice to bring up to the Assembly. I wish there were more who brought some skill in negotiating. And then when they get up there, that they keep it, and that becomes the first area they turn to instead of their political allegiance. And that is something that I have learned. As much as attorneys can bring some practice in negotiating and trying to reach a deal and a compromise, which I personally do not think is a bad word. Once they're in the building in Sacramento, it's like a bubble. I don't know if it's the air, the water, whatever happens, but the political influences generally predominate first, particularly with respect to your caucus and what group you're with, what party, what side of the aisle you're on. That still happens in Sacramento, big surprise. So there's your own practice area that you can bring skills. There's negotiating skills. I have particularly found lawyers are very valuable in committees and in hearings when there's a witness who is saying the bill does something that it does not do. And sometimes the witness is a fellow member of the legislature. I'm just going to point that out. In our hearings, we have a witness that comes and testifies about why this bill is necessary. The first witness is always the member who has written the bill, and we should have in front of us a copy of the bill. Every legislator is provided a copy of the bill. We can get it ourselves, and they're given a staff summary and analysis. Most legislators never look at the bill language. They look at the staff summary or analysis. I read both. It is why I am practically blind without my reading glasses now. I thought I was doing a lot of reading and writing before, but it's really something else now. I have seen instances where members have said this bill does something, and I pick up the bill in committee, and I'm reading it right there, and I don't see it in here, and I have to point it out to a member in committee. That is not a function of whether or not somebody's a lawyer. It's just good diligence in your job. And I want to not leave you feeling too downhearted that every member does that, but sometimes that happens. A skill that lawyers in the legislature I see bring is they try to ground a statement in text. So if you're going to say the bill does something, I'm going to pull out the bill and show it to you where in the text. This is what we do. We are looking for the citation in the brief. We are looking for citation in code. Most of the world in Sacramento does not do that. They are looking for a policy description. They're looking for policy advocacy. They have data points that are very valuable that hopefully have come from reputable sources and been peer reviewed, but they are not grounding their argument in a text. And that is valuable. I still do a lot in paper. I'm a little archaic that way, but that is a skill that any member of the Assembly can bring. But I do notice lawyers on committees that I serve with are the first ones to do that. I try to do that. I just want to see it. Show me on some paper, give me a citation that I actually can read. I think the lawyers also in the legislature, if they're going to make a case and argue something, they want to, I want to read the original source myself. Imagine the instances where someone's written perhaps a first draft of their brief, or opposing counsel has taken a quote from somewhere. They've quoted a case the way they saw it somewhere else instead of they've actually read the case and gone through and looked at the actual quote. Site check. I mean, it's pretty basic. They don't do that up there. And that is one of the easiest ways to either throw a colleague off or try to prove that something isn't substantiated in a claim. And these are all very fundamental traits of our practice, where we are grounding in the text, we are doing our own original look at a document and making sure that it's accurate. The quotes are accurate and that the information is accurate, and we have portrayed a case or an argument to fellow colleagues accurately, just like we have to do that to judges. None of those standards apply in the legislature. I do try to bring them, and so do other colleagues of mine up there. One of the cautionary tales that I have is there's a lot of colleagues who are non-lawyers who are the first ones to say something I'm pretty sure you've heard before, and that is, well, I'm not a lawyer. You're going to know more about this than I do. I know all of us have heard this, whether it's at a cocktail party or your own dinner table with guests or in your own practice. I really encourage colleagues to not assume that just because someone is a lawyer in the room, they're going to have any more skill or ability than they do. There's a great deference, particularly on anything that has to do with the judiciary or the legal practice, that, I'm not a lawyer, you know more than I do. That's a phrase I hear a lot, and I challenge it. Secondly, I didn't go to law school instead of business school because I don't do numbers. I'm sure some of you have actually said that statement. I have done it myself. It's not why I went to law school. It's just a little extra benefit. And so you'll see a glossing over of eyes from folks who, once they have to start to deal with the budget or actual numbers as they are affecting our state and what a bill does. Can't have being a lawyer make an excuse for that. You have to actually step up and try to understand what it is. Easier said than done. I also have the best staff in the building, so they help me with some of those points. So those are the general, I find, the most obvious observations about the good that lawyers are bringing, I think, to the legislature in terms of grounding arguments a little bit more in actual text, maybe a little bit more diligent when arguments are thrown out there. Go look at actually where the quote is coming from and the authority. Show me your authority for that. Who said that? And what's their basis for it? And you'll find that that can sometimes make an argument better or weaker. Find them also very helpful in negotiating skills, if they have any. I wish all of my good colleagues had great negotiating skills and that they can put the politics aside. Doesn't always happen. There are a couple of bills that are an example of how attorneys can still come up with really terrible legislation, and they can come up with great solutions. I'll try to give you one of the examples that I most recently saw this last year. And that has to do with a lot of attacks that there have been in the legislature on alternative dispute resolution, particularly arbitration and arbitration clauses in employment contracts and services contracts. Our arbitration and alternative dispute resolution is constantly under attack in this legislature. There is a viewpoint that I will try not to caricature that is alternative dispute resolution is unfair to the claimant, especially when they are required by some contractual agreement they reached to go into arbitration or other dispute resolution. It's unfair, and the best solution for disputes from a plaintiff's perspective is the traditional court system. And then there's a viewpoint on the other side, which is, well, you're just trying to take advantage of business and raise costs so that we have to be in a settlement position that we otherwise wouldn't be in. These are all fundamentals that I'm sure you've heard before. And I think in California, more than just about any other state legislature I've seen, we've had bill after bill after bill trying to outlaw mandatory arbitration clauses in employment agreements, trying to outlaw even favoritism towards certain jurisdictions and venues for alternative dispute resolution. One of the bills that I personally found awful, and I'm being more candid, because the election is over, and it's nice to just really awful bill, had to do with disclosure requirements and arbitration. Now, in my law practice, I'll give just a little short synopsis of mine. I went to Cal, I clerked for a federal district court judge in Central District of California, Alice Marie Stotler, and then came back and worked at Morrison & Foerster for several years. On and off, mostly in complex commercial litigation, securities law, and went on to represent individual officers and directors in class action cases where the company needed separate counsel for outside directors, mostly public company cases. After a few years, I then moved to a terrific firm that is 6-minute commute from my house, instead of in San Francisco, and that's Hope Fenton, where I still am special counsel, or other counsel, I think I'm other. They're not really sure how to categorize me, but it's a terrific firm. I don't keep an active book of business. I didn't want even the appearance of a conflict of interest, take the judicial standard, and but do work in continuing legal education at the firm and maintain a good connection. So that is the legal background I came from. I have been in arbitration, I have been in mediation, both in courtrooms with administrators as well as before private contracts with jams and otherwise. And have seen the value that it has when there are cases that we lawyers just don't seem to be able, and our clients don't seem to be able to reach an agreement. Well, there was a bill that came forward, and it was very concerned about the potential conflict of interest that an arbitration entity, whether it's jams or the individuals there, may have in trying to resolve a case without favoring one side or over the other, because you might have future business. So let's say a large firm is always doing business with certain retired judges at jams. And that's where we always want to have our cases. And so the other side is disadvantaged because whoever the jams arbitrator is, mediator, they are going to favor our firm because we send them a lot of business. And so there was this concern that mediation and arbitration were just being tipped, the scales were being tipped in favor of those who keep sending business to those who are helping them resolve this dispute. Okay. So the bill said you can't have a matter before a mediator that you also want to then ask them to look at another matter unless you get the other side's approval. Let me say that a little more clearly. Let's say I have a pending mediation before a jams retired judge. My law firm can't then contact jams and try to schedule another one with a totally separate client in a completely different matter, or someone at my law firm with whom I'm not even talking can't call and try to schedule one because I've got a pending matter unless I get the other side's approval, which empowers the other side, and this may make me look very cynical, empowers the other side in my matter to not allow this to go forward, which could hurt my law firm and my ability to represent my clients. So it basically, it was in the name of preventing conflict of interest, but I think it would make it completely unworkable for law firms to access alternative dispute resolution for their clients, and it would make it unworkable for those who provide it. It would eventually drive people to our court systems, which I'm pretty sure all of you know are pretty well stocked up. And that bill actually passed out of committee. I was surprised that it did. Passed the Assembly floor. And thankfully, Governor Brown vetoed it. Lawyers were the only ones in the room who were saying, as I was, wait a minute, this is totally unworkable. You're going to bring alternative dispute resolution to a grinding halt if you put this requirement in here. Lawyers were also the ones who wrote the bill, chair of the Judiciary Committee in the Assembly, in the name of preventing conflict of interest. The governor's veto message, I think, summarized very well why this was a problem. It would make alternative dispute resolution unworkable, and there are already a lot of disclosure requirements that are both those who do mediation, arbitration, have to have under existing law. And the system is not broken in that respect. If there are other needs in order to prevent conflicts of interest, find me the problem first, and let's try to zero in on that. And I'm open in the Q&A. If you want to identify some for me, I'd like to hear it. But I found that bill to be a real problem. The attorneys were the ones, like me, who were saying, wait a minute, this doesn't work. But attorneys were also the ones coming up with it. And what that showed me is it really depends on what your practice is. I did a little stint from time to time in 2 DA offices. That does not make me an expert in prosecution and criminal law. And sometimes lawyers, we're in a family here. We are the first ones to think that we know about an area of law because we have read one case on it, or we might have had one client for a short period of time in that area. It's different when you think you know that area and now you can write the law on it. There were a couple other instances where it was helpful and also harmful, some of the bills lawyers came up with in the legislature. There was another one that had to do with court reporting. And the bill was to require, this was a bill that was sponsored by courtroom court reporters, and it was to require extensive additional CLE requirements for those who do depositions but don't do courtroom transcription. And the argument for it was that if you don't abide by our standards that we are bound to as court reporters, you're not as accurate as we are. And we've got examples of cases where you might have even had a conflict of interest. Again, you are always working with the same law firm, and you want business from that law firm, so you may change the transcript based on how you want to favor that law firm. Look, I found that not credible for a variety of reasons. These deposition companies need to stay in business by providing us with credible transcripts that are accurate and that have what we need in it. Also found it not credible because the witnesses, all the examples they gave showing how if you have an inaccurate transcript you're going to have injustice were from courtroom reporting. And I pointed that out in the hearing. Every single example they had of a transcript being inaccurate and hurting someone was from those who already have those CLE requirements on them. You will see those kind of political battles. That was a political battle. You will see those kind of battles happen. There are industry groups that find a favorable member who wants to stand on their side for justice, and you just have to bring some real practical experience. Mine was working with deposition companies, transcriptions, and knowing that I need an accurate product, and it doesn't do me any good. The second somebody's product is accurate and it doesn't work for what we need to have, I will never do business with them again. I have an incentive of my own on behalf of my client to make sure that they get a good product. Again, during the Q&A, I would love to hear any challenges to that, or you might even have some horror stories, but we'd have to look at what was the reason why and what was the area where it happened. So that's some minor case studies. In the materials that are handed out today, I wanted to talk about one of the big battles where I think lawyers actually are working to save the day, and that is with our state bar. It's a great topic. We just had bacon for breakfast. We're all going to have a little bit of indigestion from hearing about this. The California State Bar has been under intense scrutiny, particularly for the last 2.5 years, last 24 months. And I think rightly so. The State Bar, just we all know this by way of reminder, is both a professional trade association, which advocates on issues and has programs, and they are like a trade association, kind of like the California Medical Association is, but they're also a regulatory and public protection entity to make sure that there are only those practicing law who are licensed to practice law in California, who met certain requirements, and then when there are complaints and disciplinary problems, there's an entity that is investigating those complaints to look out for the public good. And there are 184,000 active members of the California State Bar, about 55,000 who are in inactive status, and we have the largest state bar organization in the country. They've had some major problems in key areas for the last few years. You may recall there was leadership within the State Bar that was fired, had a whistleblower claim, because they had called attention to staff that was padding their, not only their evaluation for extra pay, but there was a lot of public, probably about 3 years ago, public coverage of malfeasance within the State Bar. And so audits started happening. One of the committees that I serve on is the Joint Legislative Audit Committee. It's called JLAC. When I learned I was on this committee, shortly after I was elected, I thought, who did I tick off that I'm on a committee that I can't pronounce? JLAC. It is one of the best committees in the legislature. It works with the independent, nonpartisan state auditor, and we have one in California, to tell them to go audit a state entity with the forensic skills and the auditing skills that you have, independent from party and any political forces, and come back to us and tell us what they're doing right and wrong. And then we can take action without passing a bill from the governor. We don't have to get the governor or go through a whole legislative process to get the state auditor. So in 2015, the state auditor audited the State Bar, found a lot of problems, primarily in transparency, in their financial records, their management of their operations and expenses. They had a horrible backlog for disciplinary cases and complaints. It would take over 1.5 years, almost 2 years, for someone to get any kind of contact or resolution when they made a complaint to the State Bar. This is something that is not good for our profession, and not only for our image, but for those that we seek to serve. And Some of the issues, and I actually brought the list of horribles that they were having are bad. The 2015 audit report found that they had set up the nonprofit entity and started expenses for that nonprofit entity even before it was set up. They have incredibly high executive pay that is out of the norm for any other state. I realize we have the largest state bar, but you always want to take that into account. The state bar had settled cases in order to get caught up on some of the cases of complaints they had. They had settled them too quickly and with very lenient outcomes for disciplining attorneys, and they were pretty open about the fact. They said, well, we just got to churn this out. We got to catch up. I mean, when you have a lot of cases on demand in your office, your solution isn't to let me find the best ways to cut every possible corner in quality for my client. I know it's not every member here of the bar is not going to be someone who does that. Well, the Bar Association is doing that. And they had major budget problems. They couldn't actually track where their bar dues were, how much they had in them, and how they were spending them. So, to their credit, the legislature, before I got there, passed legislation to say, you're going to have to fix this. We have to reauthorize their bar dues every year or so. And so we put some metrics in there that they had to reach. 2016, another audit came out. This was in May, and you have the summary of that audit, a fact sheet from the state auditor, which I can't read it all because I do now have my reading glasses. But I do remember that the Client Security Fund was found to not have the funds to pay for dishonest attorneys. So when a claim was reached and they found you needed to return funds to someone, they didn't have the money for it. You're paying into that fund, and that's what the money is supposed to do. That is all that money is supposed to do. They also found that because the State Bar doesn't have a process for tracking and distributing costs, it wasn't able to identify where funds that were restricted for some purposes were going and track if they had gone that way, and they were very inconsistent in their reporting for that. They had repeatedly changed the way in which they reported costs to the legislature, which raises red flags for us if we're doing our job. Victims of dishonest attorneys were experiencing significant delays in getting reimbursement for their claims. We saw that the total amount of time from receipt of a complaint to a final decision averaged 605 days. That's not good. So these were some of the problems that the State Bar had. What was being done about it? Well, this year, the Judiciary Committee, in a bipartisan way, and just about every attorney on the Assembly floor said no more. There was a reauthorization bill that was brought forward to us from the Senate, and it was too weak. And it's the only bill that I have seen lose on the Assembly floor with only 8 votes in support of it. It was unprecedented. One of the articles in your material is about how on earth did the majority party allow a bill to come to the floor that only got 8 votes. You need 41 just to pass. That's because there was a concerted, organized effort among the attorneys in the legislature to talk to our colleagues on the floor when that reauthorization bill came up to say, don't vote for it. We want to send a message to both the bar and to our colleagues in the Senate that we have to do something better than this and have much more stringent reporting requirements, financial requirements, have regular audits, and even be in the conversation and study about the deunification of the bar from its disciplinary and regulatory oversight to its trade association functions. That is an area that our Chief Justice of the Supreme Court has been concerned about, has expressed concerns about deunification. I believe there at least needs to be a study. We at least need to have a full hearing and understanding of whether or not this is necessary and helpful. So a bill, and I haven't made it as dramatic as it probably should be, the majority party never lets a bill come to the floor that they don't think is going to pass. And they did not know it was going to lose as dramatically as it did because we organized that very quietly on the floor at the time. Sent the message to the Senate. They brought back another bill that we were able to pass 78-0. And that was one that I think is not as strong as it should be, but it had a couple of key provisions in it that are getting us back on the path, getting the bar back in order. One is it makes sure that there are more transparency measures in place for their reporting to the legislature and how they deal with our money and client money and the disciplinary procedures. It also starts to set up metrics for when you actually finish and need to bring a complaint from start to finish so that we don't have 605 days when someone has had a problem, a disciplinary matter with an attorney. Unfortunately, the bill took out the requirement that there be a study of the deunification process, and I'll say a little bit more about that. California Medical Association, for example, making a trade association for the legal profession similar to what the CMA does. They do advocacy on legislation. They do recommendations for standards and procedures, but they don't discipline their members. That is done by a state medical board. And that's kind of the split that we're looking at the possibility of making for the state bar. That's not the only problem the bar has. If we deunify, but we don't have transparency measures, we don't have accountability measures, we don't allow audits of the state bar, especially on the regulatory side, we're not going to get anywhere. But breaking up that relationship and getting the bar, at least as a government agency, focused on the most important task, which is the regulation of the legal profession and helping those in California who've been subject to bad experiences with attorneys to get recourse. I hope that we'll be able to bring this back, the deunification issue, next year. Our Chief Justice, again, is not comfortable with that, but there are other justices on the Supreme Court, which of course has the main authority over the state bar, who desperately want it. So I will keep you posted on those, but this was an area of hope, because had lawyers not come together and been pretty aggressive with the political process on the assembly floor, a very, very weak reauthorization bill would have passed, and we were able to get some good measures going forward. And it was done in a bipartisan way. The debate on the bill was an hour, and it was every lawyer in the assembly raging against the state bar, and which felt pretty good, I will say, but bringing solutions. It's not enough to just beat them up and say what they're doing wrong as an organization. You got to come up with solutions. We did, and we got some of them passed. So that's a little bit about what I have seen as a value for attorneys in public service. I focus primarily on the legislature, because that has been my experience primarily. And I'm hopeful. There are a few more lawyers that have moved over to the Senate from the Assembly, and so we have fewer now in the Assembly than before. And I'll tell you, I was having dinner with some friends in San Francisco from some of the law firms I've worked with about a year ago. It's right after I had voted on about 1,500 bills in about a 2-month period. So I was ready for dinner with a bunch of lawyers, and I could not believe how refreshing it was to talk about CEQA and what could we do to make it better, and a couple of the class action situations they were in, because it was just very refreshing. One of the number one things that I value is being able to come out of Sacramento and go back to my firm and actually hear about the cases that are playing out the laws that are made, many of them, in Sacramento. It is very valuable for me. I wish every member of the Assembly could get a little taste of that when they go back to their districts, and that very unique way, because we do see a lot of the impacts of what's actually being passed up there if we stay active in our practice. So with that, and there's plenty of other war stories I could throw in, I would love to entertain some questions. I hope you will see that lawyers are not good for absolutely nothing. They have made a contribution in the legislature, and some unique skills that they bring, some great bills that they are champions of, some that we need to fight, and we can value some outside input reminding us why they're not good bills. But open up for some great questions. I know you got them ready. And thank you. Over there, and I'll repeat the question if you can't hear it.
In the first part of your speech, you spoke a lot about the importance of facts in your mind. A lot of observers say that this election has shown us that we live in a post-factual era where, to the voters and the elected officials, facts just don't matter anymore. So I'm wondering what perspective you have on that in your experience.
Oh, I have some experience with that. And I have it but not only on the political side, but even in hearings. You know, it's interesting. I find that the lawyers on a committee, and I do this, when I'm asking a witness something, I'm trying to draw out testimony that I can imagine on a deposition transcript or maybe up before a jury someday. I want that answer that I'm looking for to get real information. And you find yourself wanting to have facts that you will take away from that hearing that you can show others. There are no transcripts of any of the hearings in Sacramento. Video recordings are actually not something that are all that easy to get. You can order them from Cal Channel, which is like C-SPAN. If you're ever having a hard time falling asleep at night, I highly recommend Channel 108 and 107. So there are those of us who are looking to base things in facts, build a record for a bill as it's going forward, and be able to say, I remember in the hearing, this is what the witness said, and here's the basis for it. That is unusual. And it's unusual, I think we've seen that in an election cycle. And I will tell you, I'm here with my state hat on, state assembly member, and I keep a firewall between anything campaign related and my state office. So I'm going to be a little bit general in what I'm about to say. But I have definitely seen facts not used in politics, because you can say just about anything, especially about public officials. And unless it's with malicious intent and you know it is false, you got to have both. It's not good enough that it's false, or that you were negligent about it, or that you were careless. It has to be with malicious intent. You don't really have a case to stop someone. This is kind of in the area of law, so I'll give you an example. TV ads in the election that just came forward in Assembly District 16, my district, said that I had not voted for certain bills. I was the only Republican to vote for SB 32 on greenhouse gas reduction. I was one of only 2 Republicans to vote for climate change legislation last year. I voted for equal pay for equal work legislation in California, an historic bill. I voted against one that did nothing, and actually was vetoed by the governor for that. So I had an actual vote record, and the ads actually said voted against those specific bill numbers. And where I could print out the bill vote tally and show, I did. We actually sent a cease and desist letter to the television company saying, this is malicious, this is not factual, and the only way in which it can be getting out there is with malicious intent. They didn't take them down. You know, the TV companies have dollars that they're getting from this, and they have lawyers that look at the letter. And in the end, they stayed up on the airwaves, because the standard is so high to keep the public discourse from being stopped from whatever you want to say. This was an election, and I don't just mean mine, I mean at the federal level, where it was hard to find out what the facts are, I would say on both sides. But we have the First Amendment, and I don't see folks who've been through really tough campaigns coming forward with a bill that's trying to squelch their opponents even more. I mean, think about that. That was one of the criticisms against the president-elect. He said, I'm just going to sue more people. And look at the outrage that folks felt about it. So all the more reason why our own marketplace of ideas needs to be robust. And you won't see a bill from me trying to squelch speech, even if it's really bad and not factually correct, because I don't think it would pass even constitutional muster. A bit of a rambling answer, but I wanted to give you a real-life example of how facts aren't there. Other questions? Yes?
What inspired you to move from traditional legal practice into the role of public servant?
I'll repeat that one. And it was asked in such a nice way. What inspired you to leave traditional legal practice and go to legislature? Usually I'm asked a slightly different way, like, what happened to you that made you do this? Did you hit your head? And I had always been active in the community in one way or another. You just have that bug and you can't get rid of it. I had, 20 years ago, I was a congressional aide for a member of Congress who represented my hometown of Palm Springs, and that was Sonny Bono. I was his senior legislative aide in Washington for the time that he was up there. But after law school, I had been working as a junior associate at a large law firm, so didn't have a lot of free time. But found what free time I had, especially when my children were born, to be very active in school, very active in things. And I particularly saw things happening in education with my 2 kids, and I wasn't going to sit by and do nothing. And you feel powerless if you are doing nothing. In particular, my kids in 4th grade had, I have twins, so they're, I just get to mess them up all at once. Don't have the experience of one and then I get it right with the second one. They were in the same classroom, had one of those instances that was probably a teacher who should have retired and or should not have been in that profession, a high test score school. And I did everything I could to try to help in the classroom, and everything I possibly could. I got on every committee I possibly could to see if that had an impact. I went to the principal and I said, what thankless committee have you not put me on yet that fixes this? And I started looking into the law and what the law does to protect and not protect from making sure this doesn't happen. And he said something to me that inspired me to run, and that was, there isn't anything you can do about it here. There's nothing you can do. I said, where is this coming from? He said, Sacramento. I said, that is where I'm going. And so I ran for education originally to get in the room where the decisions were being made about what our laws were going to be. And I'm a big believer in that. Whether it's any organization I've been in, what room do I need to be in to be at the table to have conversations to fix things? And that was how. And that's why Assembly is where I'm at. I'm right where I feel I both want to be and can be of most service for what my talents are and what I think needs to happen in California. So I didn't hit my head, and it wasn't that the billable hour was driving me crazy, although I don't miss it. But it was something that, that's the way it happened. You know, someone describes it very organically, but that's like describing food. So, and I will say, on that billable hour point, just an aside, I can be in a room, if you're in a room with 10 attorneys, 5 attorneys from your law firm, there's a little clock that's probably going off in your mind for your client that this meeting needs to be efficient because it is costing my client a lot of money. That is a very valuable ethic to take with you into how to run an efficient meeting, an efficient hearing, and get work done. You can be up there, and I have literally thought to myself, if anyone in this room had ever had a billable hour, they would get this moving along because we need to get some work done. And you don't need 20 people in the room to do it. And so if we can bring a little more of that to Sacramento, that would be nice. Another good one. Yes?
What rationale or bases have you heard against the deunification of the state bar?
The question was, what rationale and basis has been put forward for against splitting the state bar from a trade association to a regulatory quality control? And most of it is from what I've seen, and I think I don't think it is political. Most of what I've seen is they don't believe the problem is that there's a conflict between the trade advocacy and managing the regulatory side. I have to say the Chief Justice has made a very strong case for modernizing the state bar, for needing to bring more accountability and transparency. I don't find that to be persuasive for me, that it's the idea that the system isn't broken. I think it is. It's just like with the FAA. They are both a trade association and a safety regulatory entity, and they have many, many problems, just like BART. BART has a lot of things that it needs to get in order, and I'd like to split off from BART the ability to, when you want to look at an extension, let another entity look at the extension. You operate the system, and then when an extension has been finished, bring it into the BART system, and now you operate a little bit more of a system. So there's lots of analogies for where splitting things up can be better, especially when you've got an entity that is like to change, trying to move the Titanic. That's been the main claim, and I hope that we can change that. I at least want to have the conversation. I would like us to have some really strong hearings on the issue and learn from what other states have done. And if we're the ones going forward, blazing the trail, see if we can get it done. So, yes?
Why can we not directly elect our own president? Or why, if the issue is serious, you serve as your vice president and then become president the following year?
And why, was the question, why
don't we directly elect our own president?
Why do we not directly elect our own president?
From the membership.
From the membership. Oh, of the Bar Association. Okay. I don't know the answer to that question. I know the one at the federal level. I can talk about that. But I do know that one of the areas of reform that is looked at is to change the composition of the bar, the state bar, so that we actually have a majority of non-members on the Definitely have good representation, plenty of attorneys, and actually require that they have some areas of expertise that they're bringing, and it can't just be anybody, that they have to have some area of expertise, not just in law, but possibly also in management. And that has been something that was pulled out of the reform bill. The one that we had, the 78-0 vote that was good after we killed the weak bill, it had that request, that we actually have a smaller board of directors and that we have more non-members than members. I'm curious what people would think about that. But I don't know the answer to why we don't elect our own bar president directly. There's a lot of appointments to who's on the bar. And they are political. The speaker gets one, the president of the Senate gets one. They come from a couple different spots, but worth looking into. Thank you.
All right.
All right. Well, thank you for letting me.
Thank you to Catherine Baker for joining us today. We're really lucky to have someone who's so engaged in Sacramento for our district. Folks, we're about to head on to our sessions. Please make sure you sign in on the orange sheets in the back, and I'll see you at noon.